Let's face it, without the idea of truth, we never would have become independent from Great Britain. From the Declaration of Independence, we read, "We hold these truths to be self-evident." There are things that are not only true, but so obviously true, we should not need to write them down. Everyone used to agree they were true. While we rarely agree on what the truth is, we still generally agreed that there was a truth we could find. Knowing there is a truth is one thing. Finding out what that truth is might be something else. So if you want to be free, finding out what the truth is should be our first step. I recently received a question based on an article entitled, "Feds Have Tied the Hands of Tennessee Law Enforcement on Illegal Immigration. Tennessee Leadership Refuses to Push Back." It would appear, at least according to the author of this article, that not only is Tennessee law enforcement being restrained, but our legislature and people as well. The position of federal supremacy comes from a statement I found in the article. According to the Department of Homeland Security, under the Supremacy Clause in the Constitution, the assignment of immigration law and enforcement of those laws is given to the federal government. And in order to comply with a cooperation-only approach, states are relegated to a prone position, at least under the Biden administration. It would seem that the hands of all Tennesseans are well and truly bound by the whims of the Biden administration. That is except for one small thing: the truth. According to the Department of Homeland Security, the Supremacy Clause of the Constitution gives the creation and enforcement of immigration laws to the federal government. However, the Supremacy Clause, found in Article 6, Clause 2, says no such thing. In fact, the Supremacy Clause reads, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land." In order for any law to be considered the supreme law of the land, it must be made in pursuance or following the Constitution, which specifically states in the 10th Amendment, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." So for a law of the United States to be the supreme law of the land, it must put into effect a power delegated to the United States by the Constitution. Now, a quick look at Article 1, Section 8, Clause 4 shows that Congress has the power to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. So Congress has the power to create rules for naturalization, which, according to Webster's 1828 dictionary, is the act of investing an alien with the rights and privileges of a native subject or citizen. It does not grant to Congress the power to regulate immigration, which is the passing or removing into a country for the purpose of permanent residence. In fact, the term immigration does not appear in the Constitution of the United States. This means that Congress does not have the legitimate power to regulate immigration. Therefore, federal immigration laws are not the supreme law of the land and, in fact, are void and meaningless. The Supreme Court stated in the 1886 case Norton v. Shelby County, "An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed." So it seems that the federal government has not tied the hands of Tennessee law enforcement or the law enforcement of any other state. Rather, these states have not only tied their own hands, but enslaved themselves to a lie. If only there was a way to set them free.